I found out my lakefront dock was being sold at an HOA auction when my neighbor Gary called me at 6 in the morning asking if I'd lost my mind. That morning changed everything about my quiet life in Coeur d'Alene, Idaho, where I'd owned waterfront property for the past 8 years. My name is Zachary Jenkins, and I'd bought the property back in 2018 specifically because of the private dock that came with it. The previous owner had built it in the 1990s, and it was grandfathered into the newer regulations that prohibited personal docks in our subdivision. When I purchased the house, that dock was explicitly listed in the deed as part of my property. I had the surveys, the title insurance, and every document you could imagine proving that 60-foot stretch of wooden planking extending into the pristine waters of Lake Coeur d'Alene belonged to me and me alone. "Zach, what the hell are you doing?" Gary's voice crackled through my phone that Wednesday morning. "Sharon from the HOA just posted that your dock is up for auction next week. Says you've been illegally occupying HOA property for years." I sat up in bed, my heart already pounding. "What are you talking about?" "Check the HOA website. She posted it last night." I hung up and grabbed my laptop, my hands shaking as I navigated to the Pine Lake Estates Homeowners Association website. There it was, pinned at the top of the announcements page in bold red letters. The post claimed that the dock adjacent to 4472 Lakeshore Drive, my address, had been unlawfully occupied by the current resident and would be auctioned to the highest bidder to recoup years of unpaid association fees related to waterfront maintenance. My coffee mug slipped from my hand and shattered on the hardwood floor. This had to be a mistake. I owned that dock outright. It was on my property, built on my land, maintained with my money. I'd replaced boards, repainted it twice, and even reinforced the pilings 2 years ago after a particularly harsh winter. The HOA had nothing to do with it. I called the HOA office immediately, but it was too early. The recorded message said office hours didn't start until 9. I spent the next 3 hours pacing my living room, staring out at the dock in question, watching the morning sun glint off the water. My boat was tied there, gently bobbing with the wake from an early fisherman passing by. Everything about this was mine. At exactly 9 o'clock, I was on the phone. The receptionist, a woman named Linda, who'd always been pleasant enough, sounded uncomfortable when she heard my voice. "Mr. Jenkins, I think you should speak with Sharon directly about this matter." "Then put Sharon on the phone. She's in a meeting right now." "Linda, according to your website, the HOA is planning to auction my property in 6 days. I think Sharon can step out of her meeting." There was a long pause, then hold music. 5 minutes passed, then 10. I was about to hang up and drive to the HOA office myself when a sharp voice cut through the line. "Mr. Jenkins, this is Sharon Kellerman, president of the Pine Lake Estates HOA board. I assume you're calling about the dock situation?" Sharon Kellerman was everything you'd expect from an HOA president who'd let a tiny amount of power go completely to her head. She was 52, had perfectly highlighted blonde hair that she wore in the same style she probably had in high school, and drove a white Lexus SUV with a custom license plate that read HOAQN. I'd had minimal dealings with her in my 8 years here, mainly because I kept my lawn pristine, my house painted in approved colors, and generally stayed out of HOA politics. "Sharon, there's been a serious mistake. That dock is my property. It's on my deed." "Actually, Mr. Jenkins, that's where you're wrong." Her voice had that syrupy condescension that made my blood pressure spike. "The dock in question was built on HOA property. The previous owner, Mr. Harrison, had a license agreement with the association to maintain it, but that agreement was never transferred to you when you purchased the property." "That's completely false. The dock was included in my property sale. I have the survey, the title report, everything. There was never any mention of an agreement with the HOA." "Well, our records show differently, and since you've been using HOA property without authorization for 8 years, we're recouping our losses through this auction. The proceeds will go toward community improvements." "You can't auction property you don't own, Sharon." "We'll see about that." The auction is scheduled for next Tuesday at 2 p.m. in the community center. If you have documentation you'd like to present to the board, you're welcome to attend our emergency meeting Friday evening. She hung up before I could respond. I immediately called my real estate attorney, Marcus Chen, who'd handled my property purchase back in 2018. Marcus had semi-retired since then, but he agreed to see me that afternoon. I gathered every document I had related to the property, the original purchase agreement, the title insurance policy, the survey maps, the deed, everything. Marcus's office was in downtown Coeur d'Alene, in one of the renovated historic buildings near Sherman Avenue. He greeted me with concern etched on his face. I'd sent him a brief email explaining the situation. "Zach, I pulled our files from your purchase. I've gone through everything twice now." He spread documents across his mahogany desk. "There's absolutely no mention of any HOA agreement regarding that dock. The dock is clearly marked on the survey as part of your property. It's within your property boundaries. The title search we did showed no encumbrances, no easements, nothing that would indicate HOA ownership or control." So they're completely making this up? It appears so, but here's the problem. If they go through with this auction, even though they have no legal right to do so, you're going to have a mess on your hands. Someone might buy it, and then you'll have to go through litigation to sort it out. It could take months, maybe longer. Can we get an injunction? Stop the auction? Marcus nodded slowly. "We can try. We'll need to file for a temporary restraining order. I'll prepare the paperwork today and we'll file tomorrow morning. We'll need to prove immediate and irreparable harm, which shouldn't be difficult given the circumstances. But Zach, I have to warn you, sometimes judges are reluctant to interfere in HOA matters. They view them as private contractual disputes." "This isn't a contractual dispute. This is theft." "I agree. Let me make some calls." I left Marcus's office feeling slightly better but still anxious. How could this be happening? I drove home along the lake, watching other docks jutting out into the water. Some belonged to the HOA's communal marina area, but many were private docks like mine. Were they going to start claiming all of them? When I got home, I found a notice taped to my front door. It was an official-looking document on Pine Lake Estate's letterhead, signed by Sharon Kellerman. It informed me that I was in violation of HOA covenants and that any items on the dock needed to be removed within 72 hours or they would be disposed of. My boat, my kayaks, my fishing gear, everything. I called Gary immediately. "Can you believe this?" Gary came over within 10 minutes. He was a retired engineer, methodical and practical, and had served on the HOA board years ago before Sharon's crew took over. He read the notice and shook his head. "This is insane. I remember when you bought this place, that dock was definitely part of your property. I even remember Harrison mentioning that it was one of the reasons he could ask for a higher price. Did you know anything about an agreement with the HOA?" "Never heard of it, and I would have known. I was on the board until 2019. If there had been some license agreement, it would have come up in our records. Sharon's making this up, Zach. Question is, why?" That was the question that kept bothering me. Why would Sharon suddenly claim ownership of my dock? What did she have to gain? The answer came the next morning when I saw who was listed as the appraiser for the auction: Kellerman Property Services, Sharon's husband's company. They'd valued my dock at $45,000 for auction purposes, which was absurdly high. The dock was nice, sure, but $45,000? That was nearly what some of the empty lots in the subdivision sold for. Someone was planning to profit from this, and I had a sinking feeling I knew who. Marcus called me Thursday afternoon with bad news. "The judge denied our TRO. He said you haven't exhausted your remedies with the HOA and that this appears to be an internal dispute that should be handled through the association's governance structure first." You've got to be kidding me. I argued that they're auctioning property they don't own, but the judge said if you believe you have superior title, you can bring a quiet title action after the fact. He doesn't want to interfere with the auction based on a preliminary review of documents. So they can just steal my property and I have to sue to get it back? Unfortunately, that's what the judge is saying. But Zach, make sure you attend that HOA meeting tomorrow. Get your objection on the record. Bring your documents. Make them acknowledge that you're disputing this. It'll help us later. Friday evening, I drove to the Pine Lake Estates Community Center with a folder full of documents and a recorder in my pocket. Idaho is a one-party consent state, which meant I could legally record the meeting as long as I was present. I wanted everything documented. The community center was a modest building near the subdivision entrance, mainly used for holiday parties and the occasional wedding. When I arrived at 6:30, about 20 people were already there, including all 5 board members. Sharon sat at the head table, flanked by the Vice President, Brenda Morrison, and the Treasurer, Dave Sullivan. The Secretary and the Member-at-Large sat on either side. Sharon's eyes narrowed when she saw me, but she maintained her fake smile. "Mr. Jenkins, thank you for joining us. I assume you're here about the dock matter." "You know exactly why I'm here." "Well, this is an open comment period, so you'll have 3 minutes to address the board when we get to that portion of the agenda." I took a seat in the front row and waited. They went through standard business first. Approval of the last meeting's minutes, a discussion about repainting the mailbox stations, a vote on new landscaping for the entrance. 45 minutes of minutia while I sat there, my frustration building. Finally, Sharon said, "We'll now move to open comments. Mr. Jenkins, you're first." I stood and walked to the podium, placing my folder down. "I'm here to formally object to the planned auction of the dock at 4472 Lakeshore Drive. That dock is my private property, as clearly documented in my deed, survey, and title insurance. The HOA has no legal claim to it whatsoever." Sharon's smile didn't waver. "Mr. Jenkins, as I explained on the phone, our records indicate that the previous owner had a revocable license agreement with the HOA for that dock. When you purchased the property, that agreement was not renewed. Therefore, the dock reverted to HOA ownership. I'd like to see this agreement. It's in our archives." "Then produce it. I've brought my complete title history. There's no mention of any such agreement anywhere, not in the title search, not in the purchase documents, nowhere. If this agreement existed, it would have appeared in the title report." Dave Sullivan, the treasurer, cleared his throat. He was a nervous man in his 60s who always seemed uncomfortable during confrontations. "Mr. Jenkins, the license agreements were handled separately from property transfers. They weren't filed with the county, so they wouldn't show up in a title search." "That's convenient. So you're claiming there's an agreement that was never recorded, never disclosed to me at purchase, and apparently never even mentioned to me in 8 years of living here? And based on this phantom agreement, you're now claiming ownership of property that's clearly within my lot boundaries?" Brenda Morrison spoke up. She was Sharon's best friend, and they'd been in the HOA together for years. "Mr. Jenkins, your tone is quite hostile. We're simply trying to manage community assets appropriately." "It's not a community asset. It's my property." Sharon shuffled some papers. "I'm afraid we're going to have to disagree. The auction will proceed as scheduled. If you wish to challenge the HOA's authority, you're welcome to pursue legal remedies, but this board has voted to move forward. Now, unless you have anything else to add in your remaining 30 seconds, we need to move on." "I want to see the agreement. I want documentation of this claim." "Your time is up, Mr. Jenkins. Thank you for your comments." I stood there, furious, as Sharon moved on to the next item on the agenda. The other homeowners in attendance looked uncomfortable, but no one spoke up. That was the problem with HOAs like this one. People were afraid to challenge the board because they didn't want to become the next target. I left the meeting and immediately called Marcus. "They're proceeding with the auction. They claim there's some unrecorded license agreement, but they won't produce it." "Of course they won't, because it probably doesn't exist. Zach, here's what we're going to do. We're going to let the auction happen, but we're going to make sure it's very clear that you're disputing ownership. I want you to attend the auction, state your objection publicly, and make sure everyone there knows that any purchase would be subject to litigation. That way, hopefully, no one will bid, or if they do, they'll be on notice that they're buying into a lawsuit. And if someone still bids? Then we file a quiet title action immediately and get an emergency hearing. Once we're in front of a judge with all your documentation, this will get sorted out. It's just going to be expensive and time-consuming." The weekend was torture. I spent Saturday and Sunday staring at my dock, watching people drive by slowly, clearly casing it out for the auction. On Sunday afternoon, a couple in a luxury sedan actually parked in front of my house and walked down to photograph the dock. I went out to confront them. "Can I help you?" The man, probably in his 40s with expensive sunglasses and a polo shirt, smiled, just looking at the dock, thinking about bidding Tuesday. "You should know that dock is my private property, and any purchase would be immediately challenged in court." The woman, equally well-dressed, laughed. "The HOA has clear title. We checked with them. They sent us the documentation." "What documentation?" The license agreement from 1996. The previous owner, some guy named Harrison, signed it. Agreement says the dock was built on HOA property with permission, and the agreement was revocable at will. My heart sank. They'd actually produced a document. Can I see it? Not our job to show you HOA paperwork. Take it up with them. They walked back to their car and drove off. I immediately called Marcus, even though it was Sunday. They have a document, some kind of agreement from 1996. Fax it to me the moment you can get a copy. But Zach, even if there was such an agreement, it should have been disclosed at the time of sale. Your title insurance should cover this. Let me contact your title company Monday morning. Monday was a blur of phone calls and research. Marcus contacted First American Title, the company that had insured my purchase. They were very concerned about the HOA's claims and assigned an attorney to review the matter. Meanwhile, I drove to the county recorder's office to search for any recorded documents related to my property. The clerk, a patient woman named Helen who'd worked there for 30 years, helped me search everything. We found the original survey from when the subdivision was platted in 1982, my deed, Harrison's deed from when he bought the property in 1994, every subsequent transfer, and various easements for utilities. No license agreement, no mention of HOA control over any docks. This is strange, Helen said, peering at her computer screen. There's a notation here from 2018 when you purchased. The title company requested verification of any dock agreements, and the HOA responded in writing that there were no encumbrances on the property. I have the letter right here. She printed it out for me. It was signed by the HOA president at the time, a man named Robert Torres, stating clearly that Pine Lake Estates HOA had no claim to the dock at 4472 Lakeshore Drive, and that the property was sold free and clear of any association interests beyond the standard CC and RS. I called Marcus immediately. I have documentation from the HOA itself saying they had no claim to the dock in 2018. That's excellent. Bring it to the auction tomorrow. This is fraud, Zach. They knowingly misrepresented their interest in the property. Tuesday morning arrived too quickly. I'd barely slept. I drove to the community center at 1:30, 90 minutes early, and found the parking lot already half full. Inside, Sharon had set up the auction like a professional event. There were registration tables, bidder numbers, even refreshments. This wasn't some casual HOA matter. They'd planned this carefully. I recognized several of the people waiting. Some were neighbors, likely just curious. Others were clearly investors, people I'd never seen before, studying printouts and talking in low voices. The well-dressed couple from Sunday was there, already registered with bidder number 7. Sharon approached me with her clipboard and fake smile. Mr. Jenkins, are you here to observe or to bid? I'm here to make sure everyone knows this auction is fraudulent. Her smile tightened. I'd be very careful about making defamatory statements, Mr. Jenkins. We have excellent legal counsel. So do I, and I have documentation that your association explicitly stated in 2018 that it had no claim to my dock. For the first time, I saw uncertainty flicker across her face. I don't know what you're talking about. I pulled out the letter from Robert Torres and showed it to her. This is from your own HOA files, signed by the president at the time. It states clearly that the dock belongs to me, free and clear. She barely glanced at it. Robert Torres is no longer with the board. His understanding of the situation was obviously incorrect. The current board has reviewed all historical records and determined that the HOA does have legitimate claim to the dock. Now, if you'll excuse me, we need to start. She walked away before I could respond, but I noticed her pull out her phone and make a quick call. She looked worried. At exactly 2 p.m., Sharon took her position at the podium. About 40 people were seated in the folding chairs, with another dozen standing in the back. She welcomed everyone and explained the auction rules. The dock would be sold as is, with a minimum bid of $20,000. All sales were final. Payment was due within 10 days, and possession would transfer immediately. Before we begin bidding, I stood up and said loudly, I need to make everyone aware that this dock is my private property, and the HOA has no legal authority to auction it. Anyone who purchases this dock will be named in a lawsuit, and I will pursue full legal remedies to recover my property and damages. Several people murmured and looked uncomfortable. Sharon's face reddened. "Mr. Jenkins, you're disrupting an official HOA proceeding. Please sit down or I'll have you removed. This is a public auction, and I have every right to inform potential buyers of the legal issues." A man in the back, wearing a sheriff's deputy uniform, stood up. "Madam, is this gentleman a homeowner here?" "Yes, but he's being disruptive. He's allowed to speak at a public auction. If you want this to be private, you should have restricted attendance." Sharon looked furious but forced a smile. "Fine. Mr. Jenkins has made his objection known. However, the board has thoroughly researched this matter and we are confident in our legal position. The auction will proceed." She started the bidding at $20,000. Immediately, 3 people raised their paddles. Within minutes, the price climbed to $35,000. The well-dressed couple was aggressive, countering every bid quickly. Another investor, a man with a development company from Spokane, kept pushing the price higher. I stood again. "I'm offering copies of my deed and the 2018 letter from the HOA to anyone interested in reviewing them before bidding further." "Mr. Jenkins, sit down." Sharon's voice was sharp now, the fake pleasantness gone. But several people came forward, including one of the active bidders. I handed out copies of my documents. The man from Spokane read the 2018 letter, looked at Sharon, and shook his head. He left without another bid. 2 other people who'd been bidding also dropped out. That left the well-dressed couple and 1 other investor. They continued bidding, pushing the price to $42,000. Finally, the other investor dropped out, and the couple won with a bid of $42,500. Sharon's smile returned. "Sold. To bidder number 7, please see the treasurer to arrange payment." The couple approached Dave Sullivan, who had them sign paperwork. I walked over as they were writing a check. "You're making a mistake," I said. "That dock is on my property. I will sue you." The man barely looked at me. "We have attorneys on retainer. If you want to waste your money on a frivolous lawsuit, be our guest. The HOA has represented that they have clear title, and we'll hold them responsible if that's not true." "At least tell me why you want it so badly." The woman finally looked at me. "We own the adjacent lot. We've been trying to get dock access for years, but the HOA won't grant permits anymore. When we heard this one was available, we jumped on it. $42,000 is cheap for lakefront dock access." My stomach dropped. They owned the lot next door, the vacant parcel that had been for sale for as long as I'd lived here. If they had dock access, they could develop that lot for a premium. This wasn't just about the dock, it was about increasing their property value by hundreds of thousands of dollars. "The dock is on my property," I repeated. "It doesn't matter who owns the adjacent lot." "We'll see what a judge says." The man finished writing the check and handed it to Dave Sullivan. Sharon was already preparing a bill of sale. I watched in disbelief as they completed the transaction right there, transferring ownership of my dock to complete strangers based on the HOA's fraudulent claim. I called Marcus from the parking lot. They sold it. $42,500 to a couple who owns the adjacent lot. Okay, now we go nuclear. I'm filing the quiet title action this afternoon. We'll also file for an emergency injunction prohibiting them from taking possession. And Zach, I think we need to consider filing a criminal complaint. This is fraud, potentially theft by deception. The HOA knowingly sold property they didn't own. What are the chances of that going anywhere? Better than you'd think. I'm going to contact the Kootenai County Prosecutor's Office. Bring them all your documentation. This is several people conspiring to deprive you of property rights through false pretenses. That's a crime. That evening, I contacted Robert Torres, the former HOA president who'd signed the 2018 letter. He'd moved to Boise after retiring, but remembered the situation clearly when I called. Of course I remember. The title company specifically asked about dock agreements when you were buying. I reviewed all our records personally. There was nothing. The dock was Harrison's private property, built on his lot. When the subdivision was developed in the 80s, several lots had riparian rights and could build private docks. Yours was one of them. The HOA never had anything to do with it. Would you be willing to provide a sworn statement to that effect? Absolutely. What Sharon's doing is outrageous. I always worried when she took over the board. She's power-hungry, and I suspect she's using the HOA to enrich herself somehow. I'll help however I can. Wednesday morning, Marcus filed a comprehensive lawsuit in Kootenai County District Court. The defendants included the Pine Lake Estates HOA, Sharon Kellerman individually, the other board members, and the couple who'd purchased the dock, Dale and Patricia Hamilton. We sought a declaratory judgment confirming my ownership, an injunction prohibiting any interference with my property, and damages for fraud, conversion, and emotional distress. We also filed a criminal complaint with the prosecutor's office. Marcus knew one of the deputy prosecutors, a woman named Jennifer Walsh, who agreed to review the case personally. The next few days were chaotic. The Hamiltons immediately hired an attorney, an aggressive litigator from a Coeur d'Alene firm named Randolph Wheeler. He filed a motion to dismiss our lawsuit, arguing that the Hamiltons were good faith purchasers who'd relied on the HOA's representations. Meanwhile, the HOA's attorney, a man named Christopher Valdez, sent me a cease and desist letter demanding I stop making defamatory statements about the association. He threatened to sue me for libel unless I publicly apologized. Marcus responded by requesting production of the alleged 1996 license agreement. If it existed, we wanted to see it immediately. Valdez responded that it was in storage and would be produced during discovery. That means they don't have it, Marcus explained. If they had a smoking gun document, they'd produce it immediately to end this. They're stalling. The emergency injunction hearing was scheduled for the following Monday, exactly 1 week after the auction. Judge Patricia Morrison, no relation to Brenda Morrison from the HOA, would hear arguments. That weekend, things escalated. On Saturday morning, I woke to find the Hamiltons at my dock, accompanied by a locksmith. They were installing a gate at the dock entrance and putting a lock on it. I ran outside in my pajamas. "What the hell are you think you're doing?" Dale Hamilton held up a piece of paper. "We have a bill of sale from the HOA. This is our property now. We're securing it. You're trespassing. That gate is being installed on my land. Call the sheriff. We'll show them our documentation." I did exactly that. A deputy arrived within 20 minutes, a young officer named Deputy Stevens, who looked uncomfortable with the situation. I showed him my deed and survey, proving the dock was on my property. The Hamiltons showed him their bill of sale from the HOA. "This is a civil matter," Deputy Stevens finally said. "You folks need to sort this out in court, but until there's a court order, I'd advise against changing locks or restricting access, sir." He directed this last comment to Dale Hamilton. "We're protecting our investment. I understand, but you're installing that gate on property that's in dispute. I'd recommend you wait for a judge to sort this out." Reluctantly, the Hamiltons told the locksmith to stop, but the gate frame was already partially installed. They left, but not before Dale said, "We'll be back with a court order." I spent the rest of the weekend documenting everything. I took photographs, measurements, and wrote down exactly what had happened. Marcus filed an emergency motion for a temporary restraining order that evening, arguing that the Hamiltons were already attempting to dispossess me of my property. Monday's hearing was intense. Judge Morrison's courtroom was modern and efficient, located in the Kootenai County Courthouse in downtown Coeur d'Alene. Marcus presented our case methodically, walking through the deed, the survey, the title insurance policy, and most importantly, the 2018 letter from Robert Torres stating the HOA had no claim. Randolph Wheeler argued that his clients were innocent purchasers who'd relied on the HOA's representations. "Your Honor, the Hamiltons paid over $40,000 in good faith. They conducted due diligence by contacting the HOA, which assured them it had proper title. They should not be penalized for the HOA's potential errors." Judge Morrison was a sharp woman in her early 50s with a reputation for not tolerating nonsense. She interrupted Wheeler's argument. "Counselor, your clients were explicitly warned by Mr. Jenkins at the auction that the property was in dispute. They cannot claim to be good faith purchasers when they had actual notice of competing claims. They were informed of Mr. Jenkins's position, but they were also assured by the HOA's legal counsel that the sale was legitimate." The HOA's attorney, Christopher Valdez, then argued that the association had every right to auction the dock based on historical records. "Your Honor, we have documentation showing that Mr. Harrison entered into a license agreement with the HOA in 1996. That agreement was revocable and was never properly transferred to Mr. Jenkins." "Then produce this agreement," Judge Morrison said. "It's being retrieved from our archival storage, Your Honor. We'll have it within the week." "Mr. Valdez, Your association auctioned property based on this alleged agreement. You should have had it readily available before conducting that sale. The fact that you're now scrambling to locate it suggests it may not exist. It exists, Your Honor. We simply need time to retrieve it from storage. Judge Morrison reviewed the documents before her, particularly the 2018 letter from Robert Torres. This letter, signed by your association's president 7 years ago, explicitly states that the HOA had no interest in this dock. How do you explain that? Mr. Torres was mistaken, Your Honor. He was not aware of the historical license agreement. So your association president certified something as fact without actually checking your records? Valdez looked uncomfortable. It appears there was an oversight. Judge Morrison sat back in her chair, clearly skeptical. Here's what's going to happen. I'm granting a temporary restraining order prohibiting the Hamiltons or anyone acting on their behalf from accessing, modifying, or restricting access to the dock pending resolution of this matter. The HOA is prohibited from taking any further action related to the dock. Mr. Valdez, you have 10 days to produce this alleged license agreement. If you cannot produce it, I'm going to be very interested in hearing why your association auctioned property based on a document that doesn't exist. We'll reconvene in 2 weeks for a preliminary injunction hearing. It was a partial victory, but I'd at least secured protection for my dock in the meantime. As we left the courtroom, I saw Sharon Kellerman in the hallway, talking intensely with Christopher Valdez. She looked furious. The next day, Jennifer Walsh from the prosecutor's office called me. Mr. Jenkins, I've reviewed your complaint and the supporting documentation. I'd like you to come in tomorrow with your attorney. I think we may have a criminal case here. Wednesday afternoon, Marcus and I met with Jennifer Walsh in her office at the Kootenai County Administration Building. She was a sharp prosecutor in her late 30s, known for taking white-collar crime seriously. I've reviewed everything you've provided, she said, spreading documents across her desk. What concerns me most is this letter from 2018, where the HOA explicitly stated it had no claim to your dock, followed by the auction 5 years later claiming the opposite. That suggests intentional fraud rather than a good faith dispute over property rights. That's exactly what we believe, Marcus said. The question is whether this rises to criminal conduct. Idaho Code 182403 defines theft to include obtaining property by false pretenses. If the HOA knowingly made false representations to auction property they knew they didn't own, that's theft. The fact that they profited from the sale makes it even clearer. What would you need to pursue charges? I asked. I need to establish criminal intent. I need to prove they knew the dock wasn't theirs but auctioned it anyway. This 2018 letter gets us partway there, but I need more. I need to understand why they suddenly claimed ownership in 2023. Was there a financial motive? Who benefited from the sale? I told her about Sharon's husband's appraisal company and the inflated $45,000 valuation. I explained how the HOA treasurer, Dave Sullivan, had processed the sale and how all the board members had voted to proceed despite my objections. I'm going to open an investigation, Jennifer said. I'll be issuing subpoenas for the HOA's financial records, emails, and all documents related to the dock. If this was a scheme to defraud you and enrich the HOA or its board members, I'll bring charges. 2 days later, the 10-day deadline for the HOA to produce the license agreement passed. Valdez filed a motion for extension, claiming the document was proving difficult to locate. Judge Morrison denied it. Mr. Valdez, your association had this alleged agreement in hand when it decided to auction the property. The fact that you cannot now produce it suggests it never existed. I'm scheduling an evidentiary hearing for next week. The HOA will need to prove its claim to the dock, or I'm entering judgment for Mr. Jenkins. The evidentiary hearing was scheduled for the following Thursday. In the meantime, the prosecutor's investigation was moving forward. Detectives served subpoenas on the HOA, and I heard through the neighborhood grapevine that Sharon was panicking. Gary called me one evening with interesting news. Brenda Morrison just resigned from the HOA board. No explanation, just sent an email saying she's stepping down effective immediately. Rats fleeing a sinking ship. That's what I figure. I also heard that Dave Sullivan told some people he was lied to by Sharon about the dock ownership. Said he never would have processed the sale if he'd known it was disputed. The cracks were forming. The board members were realizing they might face personal liability for what had happened. The Thursday hearing arrived. Judge Morrison's courtroom was packed with interested neighbors and local reporters who'd picked up on the story. It's not every day an HOA gets accused of auctioning property it doesn't own. Marcus called Robert Torres as our first witness. Torres, a dignified man in his late 60s, testified about his time as HOA president and the 2018 letter he'd signed. "I personally reviewed our records when the title company inquired," Torres explained. "I checked every file we had. There was no license agreement, no HOA claim to that dock whatsoever. It was private property, always had been." "Could such an agreement have existed without your knowledge?" Valdez asked on cross-examination. "Absolutely not. I was meticulous about our records. If there had been a 1996 agreement as claimed, it would have been in our files. It wasn't." Next, Marcus called Helen from the county recorder's office. She testified about the thorough search we'd conducted and the lack of any recorded agreement. "In my 30 years working here, I've never seen an HOA claim ownership of property based on an unrecorded, undisclosed agreement," she said. "If such an agreement existed and was that important, it should have been recorded." Then came the key moment. Marcus called Sharon Kellerman to the stand. She'd tried to avoid testifying, but the judge had ordered her to appear. Sharon took the stand wearing a navy blue suit and pearls, looking every inch the professional HOA president. But her hands were shaking slightly. "Ms. Kellerman, you were president of the HOA when it decided to auction Mr. Jenkins's dock, correct?" "Yes." "And you were aware that Mr. Jenkins disputed the HOA's claim to the property?" "He made his objections known, yes." "You were also aware of the 2018 letter from Mr. Torres stating the HOA had no claim to the dock?" Sharon hesitated. "I became aware of it later." "When exactly?" "I'm not sure of the specific date." Marcus pulled out a document. "Ms. Kellerman, this is an email dated March 15, 2023, 3 weeks before the auction. It's from Mr. Jenkins's attorney to the HOA's attorney, attaching a copy of the Torres letter. You were copied on the response, so you knew about this letter before the auction, didn't you?" Yes, I suppose I was copied on that." "And yet you proceeded with the auction anyway." "We believed we had superior documentation showing HOA ownership." "This alleged 1996 license agreement?" "Yes." "Where is that agreement?" "Ms. Kellerman?" We're still looking for it." "You've had over a month. Your attorney has had multiple extensions. Where is this critical document that justified your auction?" Sharon's face flushed. "I know I saw it. It was in our files." "When did you see it?" "A year ago, maybe longer, when we were first discussing the dock situation." "Who brought up the dock situation?" Sharon shifted uncomfortably. "I don't recall exactly." Marcus pulled out another document. "Ms. Kellerman, these are minutes from an HOA board meeting in January 2023. You proposed that the board assert ownership of certain waterfront amenities that may have been improperly privatized. That was you talking about Mr. Jenkins's dock, wasn't it?" "That was a general discussion about HOA assets. But Mr. Jenkins's dock was the only property that was ultimately auctioned, correct?" "Yes." "And isn't it true that your husband's company, Kellerman Property Services, was paid $3,000 to appraise the dock for auction?" Valdez objected. "Relevance, Your Honor." "I'll allow it," Judge Morrison said. "The witness may answer." Sharon looked trapped. "My husband's company does appraisal work for the HOA regularly. There's nothing improper about that." "But it does mean you and your husband stood to profit from this auction, doesn't it?" "We provided a service and were compensated fairly." Marcus pressed on. "And the HOA received $42,500 from this auction, money that went into HOA, accounts you control as president." "The HOA received the proceeds, yes. What was that money used for?" It hasn't been allocated yet. It's in our reserve account." "So the HOA auctioned property it couldn't prove it owned, kept over $40,000, paid your husband's company for an appraisal, and the money is just sitting in an account you control?" Valdez objected again, but the damage was done. Sharon looked guilty, and Judge Morrison's expression showed she was not impressed. The hearing continued for another 2 hours, but the conclusion was becoming clear. When Valdez rested without producing the license agreement, Judge Morrison called for closing arguments. Marcus was concise. Your Honor, the HOA has failed to produce any evidence supporting its claim to the dock. Meanwhile, Mr. Jenkins has provided overwhelming evidence of his ownership: a deed, a survey, title insurance, and a letter from the HOA itself stating it had no claim. This auction was fraudulent from the start. Valdez tried to argue that the HOA had acted in good faith based on institutional knowledge, but he couldn't explain the missing agreement or the contradictory 2018 letter. Judge Morrison didn't even take time to deliberate. I'm ruling from the bench. Mr. Jenkins has clearly established ownership of the dock through multiple pieces of documentary evidence. The HOA has produced nothing to support its claim beyond vague references to an agreement that apparently doesn't exist. I'm entering judgment for Mr. Jenkins, declaring him the sole owner of the dock. The auction is void. The HOA must return the $42,500 to the Hamiltons immediately, Sharon gasped. Dale Hamilton stood up angrily. Your Honor, we relied on the HOA's representations. Mr. Hamilton, you were warned at the auction that the property was disputed. You chose to proceed at your own risk. Your remedy is against the HOA, not Mr. Jenkins. Additionally, I'm awarding Mr. Jenkins' attorney's fees and costs. The HOA engaged in frivolous litigation and attempted to deprive him of property rights without any legal basis. It was a complete victory. I felt a wave of relief wash over me. But Judge Morrison wasn't done. Ms. Kellerman, I'm directing the court clerk to send a copy of this proceeding to the Idaho Attorney General's office and the Kootenai County Prosecutor. Your association's conduct in this matter appears to cross the line from civil dispute into potential criminal fraud. That will be for them to determine, but I wanted to ensure they're aware of what happened here. Sharon went pale. Valdez tried to object, but Judge Morrison cut him off. My ruling stands. This hearing is adjourned. As we left the courthouse, reporters surrounded us. Marcus gave a brief statement while I stood beside him, still processing everything. The nightmare was over. At least the civil part. My dock was legally confirmed as mine, the auction was voided, and the HOA had been exposed. But the criminal investigation was just beginning. Jennifer Walsh had been in the courtroom, watching everything. She approached us outside. Mr. Jenkins, I'll be in touch. Based on what I heard today, I'm moving forward with this investigation. The judge was right. This looks like fraud. Over the next 2 weeks, the investigation intensified. Detectives executed search warrants on the HOA office in Sharon's home. They seized computers, files, and emails. What they found was damning. It turned out Sharon had orchestrated the entire scheme. She'd researched property values in the neighborhood and identified my dock as a valuable asset. She'd known the Hamiltons wanted dock access for their vacant lot and had approached them about the possibility of acquiring my dock through an HOA auction. The license agreement from 1996 never existed. Sharon had fabricated references to it, knowing most board members wouldn't question her. Dave Sullivan and the other board members had been misled, though they'd been negligent in not demanding to see the actual document before voting to auction the property. The emails were particularly damning. In one message to her husband, Sharon had written, "If we can push through this dock auction, the HOA will net at least $40,000. We can finally fund the clubhouse renovation without raising dues, which will guarantee my re-election. Plus, your appraisal fee is easy money." She'd also exchanged emails with Dale Hamilton, essentially promising him the dock if he bid high enough to make it worth the HOA's while. She'd coached him on what to say if anyone questioned the sale. In early June, about 2 months after the initial auction, the Kootenai County Prosecutor filed criminal charges. Sharon Kellerman was charged with theft by false pretenses, fraud, and misconduct in office. Her husband was charged as an accessory for his knowing participation in the scheme. The arraignment made local news. I attended, sitting in the back of the courtroom as Sharon, dressed in a modest black dress instead of her usual power suits, pleaded not guilty. Her attorney argued she'd made honest mistakes in judgment, not criminal acts. But the prosecutor laid out the evidence, the fabricated license agreement, the contradictory 2018 letter she'd ignored. The emails showing her knowledge that the HOA didn't own the dock and her financial motive for pushing through the auction. Bond was set at $50,000. Sharon posted it and left the courthouse without looking at anyone. The Hamiltons sued the HOA for the return of their $42,500 plus damages. That case settled quickly, with the HOA's insurance carrier paying out. Dale and Patricia Hamilton had been foolish to bid despite my warnings, but they were ultimately victims of Sharon's fraud, too. The other HOA board members weren't charged criminally, but Brenda Morrison, Dave Sullivan, and the others all resigned. A special election was held, and Gary, my neighbor, was elected president, along with a slate of reformers who promised transparency and accountability. One of their first acts was to commission a complete audit of the HOA's finances. It revealed that Sharon had been using HOA funds for personal expenses for years, disguising them as administrative costs and community improvements. The dock auction had been her most ambitious scheme, but not her first. The criminal trial took place that October. I testified about the auction, the threats, and the attempt to lock me out of my own property. Robert Torres testified about the 2018 letter. Jennifer Walsh methodically presented the documentary evidence showing Sharon's fraudulent scheme. Sharon's defense was weak. Her attorney tried to argue she genuinely believed the HOA owned the dock based on oral history and institutional knowledge, but the emails destroyed that argument. You can't claim good faith when your own words show you knew you were lying. The jury deliberated for less than 3 hours. Guilty on all counts. At sentencing in December, Judge Morrison, who'd presided over the civil case and had now been assigned the criminal case, showed no mercy. Ms. Kellerman, you held a position of trust in your community. Homeowners relied on you to manage their association fairly and honestly. Instead, you abused that trust to enrich yourself and to deprive a neighbor of his property rights. You fabricated evidence, conducted a fraudulent auction, and attempted to cover up your actions. This wasn't a mistake or an oversight. This was deliberate, calculated fraud. Sharon was sentenced to 3 years in prison, with 1 year suspended, plus 5 years probation. She was ordered to pay full restitution, including my attorney's fees, which had exceeded $60,000. Her husband received 2 years probation for his role. The HOA also faced consequences. Their insurance carrier dropped them, and the new board had to scramble to find coverage at triple the previous premium. Several homeowners sued to dissolve the association entirely, though that effort ultimately failed. For me, life slowly returned to normal. I spent a lot of time on my dock that fall, fishing and watching the sunset over the lake. The Hamiltons eventually sold their vacant lot at a loss and moved away. New neighbors bought it, a young couple with kids who had no interest in fighting over dock access. Gary and the new board implemented reforms. All significant HOA decisions now required documentation and independent review. Financial audits became annual instead of every 3 years. And most importantly, board members were required to disclose any potential conflicts of interest. I even attended a few board meetings, something I'd never done before the dock incident. It turned out that when run by reasonable people focused on actually serving the community rather than wielding power, an HOA could be tolerable, even useful. The following spring, I was sitting on my dock early one morning, coffee in hand, when Gary walked down from his house. "Mind if I join you?" he asked. "Not at all." He sat down on the weathered planks, dangling his feet over the water. "You know, when this whole thing started, I thought it would tear the neighborhood apart. But I think it actually brought us together. People are paying attention now. They care about what the HOA does. It shouldn't have taken fraud and a criminal trial to get there. But yeah, I guess you're right. Sharon made parole hearing next month. Think she'll get out early?" I shrugged. "Not my decision, but I doubt it. She never showed any remorse." We sat in comfortable silence, watching a pair of loons glide across the water. The dock beneath us was solid and secure, legally mine beyond any dispute. I'd had new pilings installed the previous fall, ensuring it would last another 20 years at least. "Hey, Zach," Gary said eventually, "thanks for fighting this. A lot of people would have just given up, paid the HOA off, or walked away. You stood your ground. I didn't really have a choice. It was my property." Sure you did. You could have let them steamroll you. But you didn't, and now we have an HOA that actually works the way it's supposed to. So thanks. I nodded, accepting the gratitude. The whole ordeal had been exhausting, expensive, and infuriating. But it had also taught me something important about standing up for what's right, even when it's difficult. The legal bills had been substantial even with the restitution order. Sharon's assets were limited, and collecting from her would take years. But Marcus and I had become friends through the process, and he'd worked out a payment plan I could manage. More importantly, I'd gained respect in the community. People knew I wasn't someone who could be pushed around, and the new board actually consulted me on major decisions, valuing my input. That summer, I hosted a neighborhood barbecue on my dock for the first time. 20 people came, including several I'd never really talked to before the auction incident. We grilled burgers, the kids swam, and everyone had a good time. As the sun set and people started heading home, a woman named Diana Fletcher, who lived 3 houses down, pulled me aside. I just want to say thank you, she said. Sharon tried to fine me thousands of dollars last year over some ridiculous paint color violation. I paid it because I was scared of what she'd do if I fought back. After watching what you went through, I filed a complaint with the new board. They refunded my money and apologized. None of that would have happened if you hadn't exposed what she was doing. I heard similar stories from others over the following months. Sharon had ruled the HOA through fear and intimidation, making up violations, imposing arbitrary fines, and threatening homeowners who questioned her authority. My fight had opened the floodgates, and people felt empowered to challenge previous injustices. The new board reviewed 3 years of fines and violations. They dismissed about 40% of them as unsupported by the actual covenants and refunded over $70,000 to homeowners who'd been wrongly charged. By the time the 1-year anniversary of the auction rolled around, Pine Lake Estates was a different community. The HOA operated transparently, board meetings were well attended, and decisions were made collaboratively rather than by executive fiat. I was sitting on my dock on that anniversary April afternoon when I got a call from Jennifer Walsh. Zach, I thought you'd want to know. Sharon Kellerman's parole was denied. She'll serve her full sentence. What was the reason? She still maintains she did nothing wrong. The parole board said she shows no remorse and poses a risk of reoffending. She won't be eligible for parole again for another 18 months. After we hung up, I felt a complex mix of emotions. I'd never wanted to see Sharon go to prison. I just wanted my dock and my property rights respected. But her refusal to accept responsibility for what she'd done made the punishment seem appropriate. Marcus called a few days later with different news. The title insurance company finally settled. They're paying you $25,000 for the stress and their failure to properly note the HOA's 2018 letter in your title commitment. I didn't even know we had a claim against them. It was arguable, but they didn't want the publicity of a trial. Take the money, Zach. You've earned it. The settlement money went toward a new boat, a beautiful fishing boat that I'd had my eye on for years. I named it Free and Clear as a reminder of the whole ordeal. Gary laughed when he saw the name. That's perfect. You should put a plaque on your dock, too. Property of Zachary Jenkins. No HOAs allowed. Life continued. The neighborhood thrived under the new HOA leadership. Property values actually increased once people realized the association was functional rather than predatory. Several neighbors told me they'd been considering moving before Sharon's arrest, but now they plan to stay. I testified one more time at a civil trial where several homeowners sued Sharon personally for the wrongful fines she'd imposed. I explained how her scheme with the dock had worked, establishing a pattern of fraudulent conduct. The homeowners won a judgment, though collecting would be difficult given Sharon's depleted finances. 2 years after the auction, I received a letter from Sharon's attorney. She was trying to reduce her restitution obligation, claiming she couldn't pay. Marcus and I opposed it vigorously, providing evidence of assets she'd hidden. The judge denied her motion. Ms. Kellerman, you orchestrated an elaborate fraud and profited from it, the judge said. The fact that you've since spent or hidden that money doesn't absolve you of the obligation to make your victims whole. The restitution order stands. I never spoke to Sharon directly after the criminal trial. I saw her once, about 3 years later, after she'd been released from prison. She was working as a cashier at a grocery store in Hayden, looking tired and defeated. Our eyes met across the store, and I saw something flicker in her expression. Anger, shame, maybe regret. I'll never know. I simply nodded and continued shopping. Gary told me later that she'd moved to Spokane shortly after that, unable to handle living in the same community she'd once ruled. Her husband had divorced her while she was in prison, and most of her friends had abandoned her. The consequences of her actions had extended far beyond the criminal sentence. The Kellerman Property Services went bankrupt after the conviction. No one wanted to hire appraisers associated with fraud. Sharon's husband managed to find work with another firm, but he'd lost his business and his reputation. Meanwhile, my dock remained exactly where it had always been, extending 60 feet into Lake Coeur d'Alene, legally and unquestionably mine. I replaced the boards every few years, maintained the pilings, and enjoyed countless mornings and evenings there. It became my favorite place in the world, not just for its beauty, but for what it represented. The importance of standing up for what's right, even when powerful people try to take it from you. The HOA drama faded into neighborhood lore, a cautionary tale shared at community events and board meetings. Remember when Sharon tried to auction Zach's dock? Became shorthand for HOA overreach and the importance of accountability. Gary served 3 terms as HOA president before retiring from the board. Under his leadership, the association created a homeowner bill of rights, guaranteeing due process before any fines or enforcement actions. They also established an independent review committee to hear appeals, ensuring no single board member could wield unchecked power. I eventually joined the board myself, serving 1 term as treasurer. I wanted to make sure the financial controls we'd put in place after Sharon's conviction remained strong. It was boring work, reviewing budgets and expenses, but important. I never wanted to see another homeowner victimized the way I'd been. My attorney Marcus became a good friend. We went fishing regularly on my boat, and he always joked that I was his favorite client because the case had been so satisfying to win. Most of my work is negotiating settlements and drafting contracts, he'd say. Your case was actual justice. We don't get that very often. The criminal prosecutor, Jennifer Walsh, went on to become a county judge. At her investiture ceremony, she mentioned my case as an example of why she'd pursued a career in law, to protect ordinary people from those who abuse power. Years passed, and the whole incident gradually became just another chapter in my life, rather than the defining event. I met a woman named Diana Fletcher, the same neighbor who'd thanked me after the barbecue. We started dating, fell in love, and eventually married. She loved the dock as much as I did, and we spent countless hours there together. When we celebrated our 5th wedding anniversary, we renewed our vows on that dock, surrounded by neighbors and friends. Gary officiated, and in his remarks he mentioned the journey we'd all been on as a community. This dock, he said, gesturing to the weathered planks beneath our feet, represents more than just a place to tie up boats or go fishing. It represents the principle that our homes, our property, and our rights matter. Zach fought for this dock not because it was valuable, though it is, but because it was his, and in fighting for what was his, he protected all of us. It was a bit grandiose for a backyard wedding, but it was also true. The fight over my dock had changed Pine Lake Estates for the better. The HOA functioned properly now, serving the community rather than ruling it. Property rights were respected. Due process was guaranteed. Sometimes I wondered what would have happened if I hadn't fought back. If I'd just let Sharon auction the dock, maybe sued half-heartedly and then given up, the Hamiltons would own it now, or maybe someone else. I'd have lost not just the dock, but my self-respect. More importantly, Sharon would have continued her schemes, victimizing more homeowners, embezzling more money, and abusing her authority. My stand had stopped that, had protected dozens of neighbors from future harm. As I approached my 15th year in the house, I reflected on the whole experience. Yes, it had been terrible while it was happening. The stress, the legal bills, the uncertainty, all of it had taken a toll. But it had also shown me what I was capable of. I'd stood up to bullies, fought through a corrupt system, and won. The dock remained my sanctuary. On quiet mornings, I'd sit there with coffee and watch the sunrise paint the sky in shades of orange and pink. In the evenings, Diana and I would share a bottle of wine and watch the stars emerge. And sometimes, when the lake was perfectly still and the world was quiet. I'd remember that terrible day when Gary called to tell me about the auction, and I'd smile. Because that dock, my dock, was still there, still mine, still standing as proof that justice, though sometimes slow and expensive, can prevail. The HOA never bothered me again. The new board was professional and reasonable, handling actual community needs like road maintenance and snow removal rather than fabricating crises to justify their existence. My annual dues went to legitimate expenses, and I could review every transaction in transparent financial reports. Other neighborhoods in the area reached out, asking how we'd reformed our HOA after the scandal. Gary and I gave talks at community meetings, explaining the importance of oversight, documentation, and homeowner engagement. We became minor celebrities in the local property rights community, though we mostly just wanted to live our lives in peace. Sharon served her time and disappeared from public view. I heard occasional rumors she was working in Spokane. She'd moved to Montana. She'd remarried. I didn't care. She was no longer part of my life or my community, and that was enough. The lake, the dock, and the life I'd built there continued. I taught Diana's nieces and nephews to fish from that dock. We hosted summer parties where neighbors could swim and barbecue. The dock became a gathering place, a symbol not of conflict but of community. On the 10th anniversary of the auction, Gary organized a surprise party for me at the dock. Neighbors brought food, drinks, and stories. Several people gave speeches about how the whole incident had changed the neighborhood for the better. It was embarrassing and touching and perfectly captured how something terrible had ultimately led to positive change. As the party wound down and the sun set over the lake, I stood on my dock, my legally confirmed, unquestionably owned, hard-fought-for dock, and felt grateful. Grateful for good neighbors, for a legal system that ultimately worked, for attorneys who believed in justice, and for the courage to fight when fighting mattered. The dock would outlast me eventually. Someday, decades from now, I'd sell the house or pass it on to heirs and someone else would own this piece of lakefront property. But they'd own it clearly, with proper title, because I'd fought to establish that ownership beyond any doubt. No future HOA would ever be able to pull the same scheme Sharon had attempted. That night, after the party ended and everyone had gone home, Diana and I sat on the dock under the stars. She leaned against me, and I wrapped my arm around her shoulders. "Any regrets?" she asked, "about fighting so hard, spending so much, going through all that stress?" I thought about it for a moment, really considered the question. Then I shook my head. No regrets. This dock, this property, it's ours. We earned it, not just by buying it, but by defending it, and we made the neighborhood better in the process. I'd do it all again. She smiled and kissed me. Good, because I love this dock, and I love that you're the kind of man who stands up for what's right. We sat there for a long time, listening to the gentle lap of water against the pilings, watching the moon rise over the mountains. The dock beneath us was solid and secure, a testament to persistence, justice, and the simple principle that what's yours is yours. And no HOA board, no matter how power-hungry, can take it away if you're willing to fight for it. That fight had defined a chapter of my life, but it didn't define my whole story. I was more than the guy who beat the HOA. I was a husband, a neighbor, a friend, a fisherman, a homeowner who cared about his community. The dock incident was part of my history, but my life was so much more. And yet, every time I walked down to that dock, every time I tied up my boat or sat watching the water, I remembered. I remembered Sharon's attempted theft, the stress of litigation, the victory in court, and the criminal conviction that followed. I remembered that justice, though hard-won, was possible. The dock stood as proof of that. My dock, my property, mine by right, by law, and by determination, and no HOA would ever take it from me again.